Welcome to Investing in Intellectual Property with Dave. Today I have a special video that I wanted to bring to you guys. Nike recently filed suit against a Colorado skiing company for what it called trademark infringement for its Jumpman logo. I want to take us out to Denver, Colorado. I actually have here the news that broke earlier this month that talks about it, and we'll go through it and I'll kind of give you guys my take on things and some learning lessons. And I ultimately want to see what you guys think. So please leave in the comments what you guys think about this whole situation after we go through the video. Let's get to it.
A local business owner hoping to cash in on the cold weather is now in the center of controversy.
Stephen Fusick started a clothing company called SkiiMan. It's designed for winter sports enthusiasts.
So I guess the first thing I want to stop the video with, again, I'm not sure. I'm assuming that this owner of the skiing company, a really good guy. I know a lot of times what you will see happen is companies try to piggyback off, and I'm not saying that's what happened here, but you will see a lot of times is companies try to piggyback off a famous mark when they're starting their company, when they're selling products or providing services. But I'll tell you one thing: for a uh, for a mark as popular as the Jumpman logo, which I mean, I think what Nike does like 3 billion in sales or some crazy number every year by selling the Michael Jordan products and that have the Jumpman logo on it. Let this be a lesson to all of you out there. It's probably not a good idea to name something, and we'll get off into what the marks look like in a little bit here, but let's not name something SkiiMan that is going to be potentially confused or look similar to a famous logo called Jumpman. That's already, at least in my opinion, as I'm going through this thing. And again, I want to provide value to you guys. So as you're looking to create your businesses, again, maybe you think of a mark that's already out there and you want to kind of put a twist on it or whatever the case may be, whether it's a famous mark or just an ordinary mark or whatever the case may be. Let's try to be a little bit more creative. SkiiMan is probably that probably doesn't come off well when the mark that is going to be confused with potentially is called Jumpman. So just a little bit of words of advice. Let's get back to it.
It also designs a logo that Nike says looks all too familiar. Denver 7 reporter and attorney Jessica Crawford shares more on what this logo actually looks like. Jessica?
Yeah, I have. So there's the mark. So let me back up a little bit. In trademark law, and this is an interesting twist because as she's going to get to, they actually got a trademark on his logo. But when you are asserting trademark infringement against somebody, the whole standard is likelihood of confusion. Are the consumers going to look at your mark and potentially or get confused with another mark that's out there that's trademark? That's the whole thing. Likelihood of confusion. And again, looking at these two marks that we have on your screen here, do you think you would get confused by the SkiiMan mark, which is on the left, and a Jumpman mark on the right? Again, let's compare. They both have, this whole the similar with the legs spread, the arms in the air. Obviously, the Jumpman logo, Michael Jordan is holding a basketball with shoes on his feet, and then the hands spread. And then in a SkiiMan mark, you have obviously skis on both of the legs. You have, again, I'm not a ski expert, so I'm not sure what the poles or the sticks are called, but those are in each hand, and then the blades are on each foot. So what do you guys think? Do you guys think this is you'll get confused and maybe think that all of a sudden Nike or Jordan has gone into the ski market? I'm not sure, but let's continue to see what she has to say.
Them right behind me so that the viewers can compare. So with the white background, that's the Nike Jumpman logo. The back background, though, that is the logo for SkiiMan. That's Stephen Fusick's business. And he's already invested money and time into it. And he says, despite Nike's threats, he doesn't want to let the brand go.
So, and again, this is another thing. The trademark office does not care that you have invested time and money into the marks, or at least they're not supposed to. When we're looking at trademark infringement and we're trying to analyze that, they're looking at, okay, is it a likelihood of confusion? So the fact that this guy is saying this, the ski company, a ski apparel company is saying, hey, I invested large amounts of money or money into the company. The trademark office, the USPTO, is not going to care about that when they're deciding whether or not they're going to cancel your mark or not. And this is actually another good lesson. It's good to go to a intellectual property attorney, a trademark attorney. Go get legal advice before you do something along these lines. I would have told him that, hey, this is a coin flip. Now, again, obviously he got the trademark, but if he would have came to me, I would have told him, hey, this is a coin flip. You may get your mark registered, you may not. But even if you do get your mark registered, do you want to wake up somebody like Nike? Because again, Nike, it's a high likelihood that they're probably going to come after you, given this situation. So, and I'm not sure whether or not he talked to an attorney beforehand or not, but that is some of the things that I would have told to him as counsel, just so he can be aware of. And then obviously he still has to make that decision on whether or not he wants to pursue trademarking a logo, but at least he's informed. That's all it's about, being informed. I'm not sure if he did it in this case, but if he would have came to someone like me, I would have told him, hey, it's a coin flip on whether or not you would get the logo or get the logo trademark. But if you do, there's one thing with getting the logo trademark. It's another thing with, okay, do we think Nike's going to come after us? And what does that look like from a financial standpoint? Because you can get the USPTO, this can, like in this case, it can go through the trademark office. You can get the trademark on the logo, but then how much money are you going to potentially spend if Nike comes after you? Because Nike is most likely probably going to have something to say about it, just because, at least in my opinion, these two marks look very similar. So let's continue to see what she has to say.
Every winter, you know where you can find Stephen Fusik.
Since I've moved out to Colorado, I have over 900 days on the mountain.
Most of those days, he's gliding down the slopes.
It's the ultimate freedom sport that you can do.
It's part of the reason he created his clothing brand, SkiiMan LLC.
Whenever I wore the SkiiMan stuff out prior to that,
SkiiMan,
it got
Jumpman.
a big, people always recognized it on the mountain, and they said how cool it was.
In 2020, he worked with an attorney to get this logo officially registered with the U.S. Patent and Trademark.
So it seems like he did at least go to an attorney. I'm going to go out on a limb and say, hey, the attorney maybe warned him about the potential of maybe Nike coming after him. So it's good that he at least talked to an attorney as opposed to trying to do something himself. Again, that's all you want to be, is informed. And again, it seems like he worked with an attorney, which is at least that's a good thing.
Office. Since then, he's created an online presence and even sold merchandise. But when he started receiving...
So, and I want to stop here before we get off into the cease and desist letters. When you go to file a trademark, it's a number of different classes. And let me see here. I'm gonna try to stop sharing. I'll do it a little later, but it's a number of different classes. So you have maybe classes for entertainment services. You may have a class for technology, electronics, things of that sort. You may have a class for legal services, financial services. Then you have a class for clothing and apparel, and that's typically class 25. So obviously, we know Nike sells clothing and apparel, and therefore they have their Nike Jumpman logo or the Jumpman logo registered in class 25. However, the SkiiMan company also sells clothing, so therefore they are registered in class 25 as well, which I kind of show that at the end of the video, but they are also registered in class 25. So that's another, maybe the big issue. If this guy was restaurant services, or he was selling technology products, man, that is so far from what Nike does in terms of, hey, selling they sell apparel, clothing, hats, beanies, things like that. And obviously they have some stores. So if he would have had this SkiiMan logo for a restaurant, again, I would imagine that Nike still would have been happy about it, but those are two different classes from clothing, clothing and apparel. Therefore, he would have had an even stronger argument when he's battling against Nike or battling against the USPTO. But obviously in this case, both sell clothing and apparel, which is in class 25, and now that's where Nike is taking even more of an issue with, and they have some good arguments to pull forth in this case. Let's get back to it.
Cease and desist letters from Nike, he could feel his business plans going downhill.
I don't know how they found out about me. I know they have a team of lawyers that this is what they do, is peruse the internet.
And that's a good that is a good point that I want to stop the video and talk about here for a second. If you have a $1 billion brand, you know it's going to be knockoffs. So you better believe that that company has attorneys that are going to notify the company legal team if something comes across their desk that is very that is similar to what they have going on. That's just a given. I have a client that I recently I'm not going to get off into that story, but you better believe that if you got $1 billion, heck, if you got $1 million mark, heck, if you got a mark that's maybe worth $100,000, that's trademark. You better believe that the company has people, whether it's legal teams or business associates or employees, that's kind of perusing the internet and notifying the legal department if something comes across their desk that's similar. That's just good business. Let's get back to the video.
And look up, small businesses.
One letter asked him to voluntarily cancel his trademark. Another said Nike may pursue any and all available legal remedies to protect its valuable trademarks.
It's what my company.
And that's a good point. Again, it's like if you get a trademark, and this is what I was going to say earlier, but I had a client that recently got a trademark, and I'm telling them, hey, you need to make sure you are putting the public on notice that you have a trademark. So put when you show your logo or your word, make sure you put the R in the circle at the bottom right hand corner to notify the public that this is a registered trademark. And then also, if you see somebody who is having a mark that may be similar or maybe infringing on your trademark, you have to be able to send them a cease and desist letter. If you think that you're going to just get a trademark and just sit on it, not do anything, not send out cease and desist letters, you may as well not even get a trademark. The whole point of getting a trademark is you have to be willing to enforce the mark. And that means at the very least, send out a cease and desist letter. Now, maybe hopefully you guys come to the table and you guys can maybe agree on some things and therefore not have to end up in court from a trademark infringement perspective. But at the very least, you have to be willing to send out cease and desist letters to people who are maybe you think are infringing your mark and tell them, hey, to cut it out and or whatnot. And so now Nike's attorneys are doing exactly what they need to do. Hey, hold on. We're going to send out a cease and desist letter. Please stop. Please stop using a mark. Obviously, if you don't get a response, then you're going to send out another one. You're trying to put this person on notice. Hey, you keep using this mark, then we're going to be forced to take action. And the court's going to want to see that when it ends up in court, as this one did. So the Nike attorneys are doing what they need to do. Let's continue at it.
Is based out of, so it would completely destroy my company.
Was this at all inspired by Nike?
No, I just
Who thinks that this wasn't inspired by Nike? Again, like I said, I'm sure this guy is a great guy and whatever the case may be, but if you think a company called SkiiMan that has a logo, what you just saw wasn't in any way inspired by Nike, I mean, obviously he's saying the right things to put himself in good position when his day in court comes, but hey, let's not be foolish here. Let's get back to it.
thought of a logo that just resembled what it is to be free on the mountain.
While a trademark helps a business legally protect its brand, it doesn't protect them completely. Colorado-based trademark attorney Adrian Fisher says trademarked businesses will often take legal action against other brands.
I want to fast forward this a little bit.
If they think there's a likelihood that consumers could be.
So that, again, as I told you earlier, the standard in trademark law is a likelihood of confusion. Will somebody look at this mark, in this case, the SkiiMan mark, and get confused with the Jumpman logo? That's what this comes down to. Now, again, provide your comments, provide your answer in the comments. Do you look at this SkiiMan mark and get confused with the Jumpman mark? Obviously, it has some differences with the skis and things like that, the blades or whatever the case may be. But is there likelihood of confusion from your perspective? That's the whole point of trademark law, likelihood of confusion.
Be confused by the similarities. The fallout can be costly for small businesses.
These business owners have to rebrand, and unfortunately, rebranding is very costly, and they go through the process again.
When a business owner applies,
and she's very right. She's absolutely right. I've had numerous clients come to me, and some prospective clients, and said, "Hey, they have a trademark dispute, and what's the potential consequences of kind of losing their situation. The fact that you have to rebrand, that's why it's all the more important to talk to an attorney before you actually a good friend of mine, one of my best friends, he looking to file maybe some trademarks for him, and with this particular trademark, he's saying, hey, what do you think about this? I'm like, hey, based on what's out there, I'm not saying you're not going to be able to get it get it registered as a trademark, but you're going to spend a lot of money doing so. And even if you did, which we'll talk about here in a little bit, it's a high likelihood that the company that is very similar to can potentially come after you. So again, just be informative. And again, are you willing to take on that risk? I'm hoping that the attorney that this SkiiMan guy retain, at least let him know the risk, because again, it can be a big risk, as he said. They have to rebrand, and that can essentially put a lot of small businesses out of business. So do you want to take on a risk, or do you want to just go with something that's completely different and it's not going to ruffle any feathers? That's something that you gotta, as the business owner and a potential trademark owner, that's something that you have to make a decision on.
For a trademark, the business usually goes through a strenuous process with the U.S. Patent and Trademark Office before they can officially receive a registered trademark. The government office tries to weed out businesses that could be too similar. Fusik's trademark made it all the way through the process in the year 2020, when applications at one point surged.
And this is a good point. And actually, you just calling a client yesterday, because typically when you file a trademark and the trademark goes through, it's normally an opposition period where the USPTO puts publishes the trademark. So it's a time period, maybe 30 days. I forget the exact time period, but it's a time period where anybody who opposes the mark get a chance to submit an opposition, saying that, hey, this is similar to my mark, or this is similar to their mark, and therefore the USPTO makes that determination on whether or not it's going to take the opposition into consideration, and ultimately decide, is it going to issue the mark or register the mark, or is it not going to register the mark? This was interesting because I know Nike attorneys dropped the ball on this, because they did not say anything to the USPTO or file this opposition opposing the mark during this opposition period. They waited until the actual mark was registered, and then they filed an opposition. But that should have probably been done. And again, it plays out like this sometimes, but it should have technically been done during that opposition period. I had a gentleman who a number of years ago, I think I just made a video on that I posted on a cracked chicken, a big chicken seasoning here in Michigan, essentially lemon pepper, some other ingredients. And the guy registered the mark, and after it was registered, he had another restaurant that wanted to trademark cracked chicken, and they filed a petition to cancel the mark. So again, these petitions to cancel the mark can come up after. However, Nike attorneys probably should have filed something during that opposition period. But again, this one snuck through, and yeah. Let's see if it's something else.
63% over the previous year, caused in part by an increase in e-commerce during the pandemic. The USPTO even made changes, like hiring more staff to process applications like Fusik's.
It was hard to know where an examiner was going to come down or what issues they would flag.
Fusik ultimately got the okay from the USPTO and no challenges from Nike until after the process was done. He's tried to negotiate with Nike to no avail.
Yeah, I can already tell you, and I think that's enough for the video. Hopefully you got the point. I can definitely tell you, Nike is not going to budge on this one. This is too important to their company. And again, I would imagine that I think this Jumpman logo is responsible for billions of dollars of revenue each year. So something that, again, you can make your decision on how similar this is. Something, at least in my opinion, that, again, it's a coin flip. I see a lot of similarities, obviously, but it's some things that are some differences. But something that is this close, Nike's, they're not budging. If it was something that wasn't as big to their bottom line, maybe they would have let it went through, and whatever the case may be. But something that's in the same class, clothing and apparel, that looks very similar to their billion-dollar Jumpman logo, you better believe they are not budging on this one. So I'll continue to keep you guys informed to see how this plays out. Please, if you like the video, hit the like button. Subscribe if you like this type of content. And if you didn't like the video for whatever reason, let me know what you didn't like about it in the comment section. Hopefully you got something out of this video. That's what I'm trying to provide is value to you guys from an intellectual property perspective. Again, dealing with trademarks, copyrights, patents, name, image, and likeness, and other forms of intellectual property. Again, I'm going to continue to bring you guys the latest and the greatest on this particular dispute. And until next time, peace.